People ask, so I'll give a brief background. I am a qualified lawyer in Canada. I practiced in Toronto, did all of my degrees in Canada except my PhD I did in the UK. I've been in the UK for a few years, but because the government told foreigners to get out, I left for Ireland. That's a joke, they didn't tell me to get out. So I'm now based in Ireland. I'm also teaching in a couple of other countries, but I'm full-time in Ireland, and then I come back here to teach this course. From my accent, I'm Canadian, so I have a home here as well as in Ireland. I travel a lot, which is why I have a cold. So if you're from Chile, I got the cold from your country. And I'll be very upset if you identify yourself as being from Chile. You have the two textbooks. The first one is the contract book by Ben. We'll be focusing on that for the first half of the course, and we'll look at the Solomon tort text for the second half. The way I operate the class is I'm not fond of talking, so I prefer to have a discussion. I find, especially at the graduate level, people learn better when there's a discussion. With that in mind, you should have seen on Moodle that you have, in my opinion, extensive notes, case briefs. The ones that are blank are for you to fill in based on the readings in the textbook. So for this one, be for the contract text. For this class, I gave you 2 readings, 2 articles to look up, and then 2 cases from the Supreme Court that came out last year and this year, I think. So the emphasis will be on more discussion. The assessment, I don't know if we have an exam date yet. They haven't told me. I think it's around the end of September. Okay. So the way that we structured the assignments was the contract assignment will be due on the 9th of September. Then about 4 weeks later, you have the exam. Then I think it's 3 weeks after that, you have the tort paper. Yeah, so about 2 weeks. Yeah. So the weightage is 25 for each essay and 50 for the exam. The essays are to be a minimum of 3,000 words, no more than 8,000. When I've done this course before, people went over 10,000, so I had to put in the cap because I have to read them and get them done. The exam would be 3 questions, problem questions, 1 contract, 1 tort, and then 1 what we call misrepresentation, which overlaps between contract and tort. And it's open book. Both paper questions have been put on Moodle, so you can see them. Take a look at them and consider them before you ask questions. Just so that you kind of grapple with what's being asked, and then if you have questions coming from that, I'm happy to take the questions. Yeah, so the course goes pretty quickly, even though there's a lot of time, it's very intensive. And for that reason, I've given you a lot of case briefs, so that's, again, to facilitate discussion so that we can put things together. I think most of you are from civil law jurisdictions. That's usually how the class works. So you'll notice, those of you from civil law jurisdictions, you'll notice some big differences with the common law. So I think discussion helps tease out those differences. Any questions about the course overall? Or about the assessments or readings? So we'll get into the first set of notes I gave you, which is the introduction to the Canadian law of obligations. Now, this is the only course in the country, unless it's taught in French, that does obligations together like this. So if you were a JD student, you'd have a tort course and a contract course. And why we put them together was there's a lot, in practice, you'll find that there's a lot of overlap. And what sometimes happens when JD students become lawyers is they don't really see that overlap until it's kind of late, when they're in an office and so on. So here we're focused a bit more on the practice aspect of obligations and looking at problem solving. So my focus is much more on what do we learn from the cases. We can criticize the decisions, which I think we will with the two that we have for today. But with that criticism, we understand what the court is doing, and that's the law. But the law can change. In the common law system, precedents are overruled, especially in Canada. So there's a lot of room, and not to be too crude, but a lot of money to be made in developing novel arguments, especially in private law, which is where we're focused on. So contract and tort form the basis of a lot of private law practice areas. It's more common in the UK to have obligations taught together or an overlap. And I mention that because Canadian law is sort of derived twice. If we look at UK law or English law, it's derived from Roman law. And I start there very briefly because I think in civil law jurisdictions that's a common starting point. But we'll quickly depart from that with English law, and then Canadian law is derived from English law. So that's why I say it's sort of derived from two sources. There's also an American influence, and we'll look at that a bit as well. But largely, and you'll see this with the contract cases, English law remains the law in Canada, especially the older cases, and more recent cases tend to be quite persuasive. So a decision on a similar issue in Canada, a decision from the United Kingdom Supreme Court, would be of value when arguing in Canada. So that's why we sort of have these different jurisdictions that we look at. Now for the assignments, I mentioned English law for that reason. You can also look at Commonwealth jurisdictions, or if you can draw in something from your own jurisdiction, from a civil law jurisdiction, that's fine, but make sure that it's pertinent to the question being posed. So I'm going to start with situating the course, briefly go through a bit of Roman law as it relates to English law, and then move into Canadian law. We'll take a break at about 7 or so. So technically, with the law of obligations, we have three areas: contract, tort, and unjust enrichment. We don't look at unjust enrichment because I think it'd be suicidal to do so. It'd be just too much to handle in an intensive course like this. You will get a bit of unjust enrichment if you have taken or will take property. So things like constructive trust come up. It's a very, very useful area, looking at unjust enrichment, trust law, in terms of practice. But as I say, it's just too much to put that in at this point. And we're focusing on, unlike property law, we're looking at personal rights. So if we go down to the origins of the law of obligations, just following the notes that I gave you, we have actions in persona, and that's what we're focusing on as opposed to actions in rem, property. But there's an intertwining that has developed over the history, and that kind of complicates things to the point that the way we look at contract and tort now is almost the reverse of how it developed. So right now, tort actions are sort of, by default, tort actions. Anything that is in contract. Whereas the way things started out was contract derived from more trespass. What's useful for our purposes with Roman law, and I'm just starting into the Roman law subheading, is that it also not only included private law, but also included cultural influences and interactions that helped shape it. Today, I would say we call that public policy, sort of broadly construed. And I think that's an important point to keep in mind as we go through. So, just reading from the quotation from the case I've cited, so far as proceedings in personam are concerned, the common law of England really recognizes only actions of two classes, whereas in Roman law, that was a lot more diverse. So when we're talking in the common law about a common law action, oftentimes we're looking at contract or tort. And common law in particular relates to judge-made law or court-made law, whereas a statutory right or statutory action would come from legislation. So we'll focus more on the court-made law. Compared to the common law, Roman law was remarkably formulaic, as far as I understand it. So in order for an agreement or stipulatio to be valid, you had to use a certain word, spondio. And it can seem as though when we go through contract and tort even, that there's some magic formula. And I think it's best not to look for that. What we'll find, and I think the readings today will show briefly, is that in the common law, there isn't necessarily an inherent or internal logic. So if you're looking at, if we think of a section in the textbook, let's say offer in contract law, you're looking at each case building upon the last one. We don't have that. The cases that we'll look at will sometimes seem to contradict each other. And what I advise you to do is to look at both contract and tort as providing cases that give you arguments for and against positions. So if we think of a traditional litigation, a plaintiff and a defendant, there will be cases that the plaintiff will use and cases the defendant will use. That's how I suggest you look at these cases, not to find an internal logic to them. I think in part, the reason for that absence of internal logic consistently is that cases are made on a case-by-case basis in the common law, and that relates to the facts of that particular case. So we can take a rule from a particular case, but as litigators in the common law jurisdictions, part of our job is to distinguish those precedents. And oftentimes we distinguish precedents based upon the facts in those precedents. So our argument is that that case doesn't apply here because factually the current situation is much different from that precedential case. So unlike Roman law, common law, as we're studying it, will not be too formulaic. So the way I approach this is to look at understanding what is the philosophy, so to speak, behind courts' decision-making. That's what I'm going to use to guide us through contract and tort. I'm not saying that I'm going to take you through a theoretical exercise. I'm basing our discussions only on the cases. But I think the cases tell us what decisions are being made or what choices are being made by the courts. And we take instruction from those choices, and that guides us through anticipating or providing advice to future clients. So down to the themes section. We have a few different themes that will come up. First is public versus private. Contract and tort are often referred to as part of private law, and we'll use that language. But I want to note at the outset that this is very loose language. These are not watertight compartments, public and private law. We will see what we might call public law considerations in contract and especially in tort. So don't think of things as exclusively private or exclusively public. The question is, and this goes into the philosophy aspect that I talked about, how are these distinctions being made, or what choices are being made based on these loose headings. Second is voluntary versus imposed obligations. Voluntary obligations are contracts, imposed obligations are torts. Voluntarily entered into obligations mean that you have the two parties, assuming a traditional bilateral contract, the two parties have outlined the mutual obligations they will abide by. Imposed obligations arise largely because some harm or a wrong has been committed against another person, but there is no contractual relationship between those two people. The third area is indeterminacy. And indeterminacy has been a particular concern of the common law. And this means the court is concerned about creating a rule that will lead to an indeterminate number of litigants. The courts are concerned with providing rights and remedies, but two identified categories of litigants. So if we take, for example, a loose example, smokers. We could say, well, that's a defined category. If you're going to sue a tobacco company, it'll only be smokers. But that isn't actually accurate, because you have a concept called secondhand smoke. And people that have incurred injuries related to smoking but have never smoked themselves fall into this category. So if you're devising a rule that you hope is limited to smokers, it becomes very difficult if you get into the details and you fall into something called indeterminacy. Because where does the line stop? It could be basically this one tobacco company is exposed to liability to everyone. And the courts are very concerned about that because the law can't operate in that way. So then if we look at the readings that I gave you a note, 2 notes, on 2 extra readings, and one is the first one in the notes from Peter Burks. Peter Burks was an expert in Roman law, among other areas, but largely private law. And he wrote, as I quoted, "It is convenient to begin with the point which is made at the end. According to the laws of our state, whatever precisely an obligation is, lawyers are only interested when it is a phenomenon recognized by their legal system." So if we're thinking about obligations, Burks is saying obligations are only those things or those areas that can be identified within the laws of a state. The difficulty with that is with the common law, we have arguments for recognizing new areas of rights. And one example is one of your essay topics, privacy. We'll get into that, but privacy has been a particular area of a particular problem area in the common law. There is no tort of privacy, but there are distinct actions that deal with aspects of privacy. But generally speaking, the common law, dating back to about 1890, when discussion of privacy as a tort started, has shied away from recognizing a privacy action. So if you're looking at, according to the laws of our state, the challenge there, what we're looking at is some things we will be compelled to ask the courts to recognize anew. We'll be asking them to recognize a novel action, a new area of law. But part of what I think is the remarkable flexibility of the common law is that that still is permissible within the system. The common law allows for this sort of organic development through time. The common law dates back several hundred years to England. So through that time, we've developed a number of precedents. The difficulty, though, I think, with that is, and this relates to the Geoffrey Samuel article, English Private Law, things get kind of confusing. So I've given you this chart that I hope sort of helps you through the Samuel article, but also situates what we're doing. We're looking at a particular subset of the common law, but not in its entirety. I would suggest this is probably the most flexible area of the common law, and to me at least, the most interesting. But, and then moving into the Wadham's article, this is where I'll turn it over to you. I think if you were to ask, so if we were to ask Stephen Wadhams is a retired professor at the University of Toronto Law School. He's known as a contract scholar. If we imagine asking him, what is private law? I think he'd be hard pressed to give a coherent response. And the reason for my conjecture is the reading I provided for you to read, chapter 1 from his book. How would you summarize that chapter? The Wadham's article. Balcon?
So referring to the readings, he refers to Blackstone starting off.
Correct.
And essentially he basically says Blackstone doesn't provide a single definition for private law. Instead, it focuses on the exclusions, so which entails criminal, constitutional, admin, taxation law, for instance. And basically when he's referring to obligations in general, he's just talking about the limitation of the application. So essentially, if you're just to refer to someone listed just as private law and just contract law, you're limiting just to contract law as opposed to obligations, which extends that scope.
Right, but and an important point I think to also note is Blackstone didn't identify contract. Which, looking back, you kind of have to wonder, well, why didn't he identify contract? Because it's a staple now. I think that speaks to the developments in the common law since the time of Blackstone. What else did you take from the Wadham's reading? What do you think he is defining as private law? Or what are the characteristics of private law that you extract from his chapter?
So I guess just a little bit more emphasis on just like the civil society. There was an excerpt where he does mention how in every single civil society you do have private laws that do focus on more just private persons and just things, and potentially just how we pretty much kind of go into a little bit more to involuntary disimposed obligations.
Right.
And I'll just something where there is essentially a potential overlap.
So what is a wrong? If we're talking about, and not just you, what is a wrong in obligations? And if it's easier at this point, what is a wrong in civil law? I know there are different, civil law is not homogeneous. But what is a wrong as far as you understand?
Wrong can be a breach of contract, or it can be a civil value.
Right.
What if we can translate that into some sort of a tort action in negligence or wrongdoing?
What's the character of a wrong then? Like you've given examples.
Per se, actual wrong is in connection with a private dealing or contract created by the parties.
Mm-hmm.
But the tort is imposed on parties without any agreement per se. It is imposed because the law is actually saying that there is a wrong for which there is an obligation attached to it.
Okay, so our definition of a wrong is attached to this concept of an obligation. An obligation that has been violated in some way is a wrong. Now that's different from what we think of in criminal law, which, by the way, I detest criminal law. I just find it very, very boring. Or I wouldn't want to practice it because if my repeat clients keep coming back, they're not exactly the most stable people, I thought. So with criminal law, we have this idea of a wrong where you have caused harm to someone. And the state steps in to say, we as a society repudiate that conduct. And if through due process we find you are guilty of this, we will levy some sort of punishment. But a wrong in private law is not the same as that. And at page 16, Wadham's writes about halfway through. The perception is that conduct is wrong, that an agreement has been broken, that reasonable expectations have been disappointed, that something belonging to another has been taken, that the defendant has done something unfair, or the benefit has been unjustly retained, while not themselves legally conclusive, have been highly relevant. And I read this to you because I think it repeats, Dave?
Then, yes.
Dan. It repeats what I pressed data on. Wadhams only gives us examples, but he doesn't define what it is. It's almost like a wrong in obligations is something that we know when we see it. And I think this is part of the difficulty with obligations. There's an absence of precision sometimes in how we discuss the topic, and therefore how we arrive at conclusions. It can seem as though an arbitrary decision was made. And I'm going to help you through working through that not all cases are just a bunch of arbitrary decisions. But this concept of a wrong, then, in private law, is remarkably relative. If we think of defamation, the wrong there is publishing a remark that makes other people think less of that individual who's the object of the remark, which is very different from a breach of contract, where arguably there's more intention. When somebody breaches a contract, they have most likely intended to do so. You don't necessarily accidentally breach a contract. Yeah.
I was going to ask if you were distinguishing between torts and breaches of contract, because I suppose with...
I wasn't right now. I was just talking more broadly, but go ahead.
I was going to say that I agree with you, I guess, in relation to a tort, but breaches of contract are more identifiable, and we don't actually care whether it's innocent or intentional.
It is to a certain extent, though. If it was straightforward, my question would be, we'd be all very poor because we wouldn't have a job. There always has to be an argument in terms of a breach of contract, for example.
Yeah, but the fight could go to what damages you're entitled to, interpreting the clause, which is a
Sure, but, and this is a topic that I think, well, usually does get a lot of discussion, good faith. Good faith has been recognized as an organizing principle in Canada. I suggest to you that there can be a lot of litigation as to what constitutes a breach of good faith, because there's a debate as to what that precisely is. Similarly, when we get into breach of contract, I think you'll find that the courts have taken a unique interpretation as to what constitutes a breach. And that separation leads to what is a breach that allows you to terminate a contract, and what is a breach that only entitles you to damages. Whereas I think a layperson or a client would say, well, a breach is a breach. So what I'm getting at is there's a lot of relativity to this idea of wrongs, and it's almost like there's a hierarchy. Some wrongs are worse than others in private law.
Without overreaching, because I know we're going to discuss later on, but it kind of reminds me of when you first with the Charles case, where pretty much the court placed emphasis on the preservation of autonomy when it comes to the contractual obligations aspect of it.
Yeah.
And just basically, you're referring back to the Adams article too. He pretty much mentioned too, if you make that distinction between, we're not looking at simply a promise, but we're looking at an obligation. Where pretty much, because once again, when we come back to it, the way I construed it was, it just reminded me of when we're looking at, you can pretty much looking at a marked departure of obligation.
Mm-hmm.
So the way I looked at it was from like contractual obligations, pretty much how you mentioned earlier about the intention going into a contractual obligation. Whereas when we're looking from like a tort narrative, we're looking at pretty much a departure from like potential harm based upon proximity.
Yeah. Although I think I have difficulty with the Wellman case, and we'll save that for a bit later. So we'll return to that point when the colleague decided. So-
Yeah, I was just gonna ask, in tort law and criminal law, isn't the wrong very comparable? Isn't it both a bit of causing harm? It was always my understanding that in most cases of a felony, you can also push civil charges.
Yeah, so to give an example, it's a very old example, but you've heard of O.J. Simpson? So O.J. Simpson was tried for murdering his ex-wife and her then boyfriend. And he was found not guilty. But the parents of the boyfriend sued him. So to give an example of what you're saying, same facts can be litigated in criminal law and in private law. So in that sense, there can be an overlap. My hesitation always with seeing too much of an overlap between tort and criminal law is, first of all, the evidential standard is very different. For criminal law, you need beyond a reasonable doubt. Private law only needs balance of probabilities, which is, if we think of it mathematically, it's like 51% likely. So I found in the past sometimes if it helps you, you can keep them kind of separate, good. Some people get confused by the two. They mix up the criminal and the tort. So that's the only, I don't know if you, but I'm just saying that as a broad statement. If you're thinking through criminal law, keep in mind there are certain differences with tort. Was there somebody else?
Well,
Yeah.
there is also a difference in remedies, of course.
Between criminal and, yeah,
Or damages, quote unquote.
yeah.
Although if there is a conviction on in a criminal trial, I guess the findings of the court would be binding in any subsequent court action.
It can be. Like,
Most likely it would be a.
yeah, it'd be taken as authoritative evidence at least about certain things.
Whereas in OJ, acquittal was obviously.
Well, OJ was found guilty in the civil trial.
Yeah, but he was acquitted of the criminal trial.
Yeah.
So that meant nothing for the tort action.
No, which was interesting because they actually still won. And if you think about that number, 51% with OJ, it was almost like the court in the civil trial was saying, well, he definitely was involved. He might not have committed the murder if we put the criminal and civil together, which is sort of an interesting overlap between the two. If you go to page 19, just under the indented quotation, what is Wadham's talking about here? The paragraph begins, a closely related question. maybe what I'll do is I'll take the break a bit early, and we'll come back at 7:15. And we can pick up on that point if you want to reread the section. So, make sure you have signed in the attendance.
It's not open for us.
Oh, really? Are you connecting to the internet?
Yes. That's why everybody's.
Shows that considerations of public policy have directly and often decisively influenced almost every aspect of private law, both in the enlargement and in the restriction of liability.
Means that public policy is ubiquitous in the development of law, but you cannot maybe see it directly. It's happening in the development of the law. It's actually the dream factor of the development of the law.
Yeah, well, he then says though that the effect of public policy in enlarging or restricting the law. Sorry?
The restriction of liability, right?
Yeah, enlargement or restriction of liability is masked by the focus on precedent. That the precedent, so if we think about, you've taken all taken that course. I'm trying not to say anything negative about it. The introduction to law or the foundations of Canadian law. So you've taken that course where they talk about precedent and so on. So what is precedent? The precedent is the rule that we extract from leading judgments, usually the highest court, Supreme Court. So how is public policy being overshadowed by precedent?
So that when you develop law, though it's driven by public policy considerations, you have to abide by the precedent. So it means that there is a boundary that you can, how far you can go to develop the law.
Yeah. So I think Wadham is trying to say that people are focused on, well, this is the rule from the case, but detach that from what we call public policy, or the policy aspects of the rule. And what I think he's trying to illustrate is, if we think of contract law, because that's one area where people seem to think things are more or less linear. You have these rules, they're set down, and that's all you need to know, the rules. But Wadhams would say in contract precedents that if you're looking only at the rules, or looking at just what's the rule from the case, you can overlook or it dampens or overshadows the public policy influence within each precedent. So why is a certain decision being made? Put another way, what decisions or what choices are the courts making in arriving at this ruling which becomes a precedent? So Wadhams is speaking to, and I wouldn't expect you to know this, Wadhams is speaking to a line within law that says there should be no public policy considerations. It should only be what we might call pure law. So if I strike you with my car, I should be responsible for that. End of it. But in reality, that's not necessarily the situation. What happens when you strike someone with your car? You could be charged, so we put the criminal law aside. in the civil law aspect, do you pay that person? In jurisdictions like Canada, we have no-fault insurance. Meaning, you pay, your insurance company pays the injured person. Now, that doesn't stop them from suing you individually for something more, but that's not the usual way of going about things. So those that are against public policy say, if I strike someone, I should pay directly all the losses that that person incurs. But why do we have no-fault insurance then?
Because some people cannot afford to pay anything, and then the victim will get no.
Well, I'd argue more than just some people.
Yeah.
I think most of us probably wouldn't be able to incur the burden if we struck someone with our car and they weren't able to work. So no-fault insurance is a way of distributing the onus amongst a larger group of people so that that loss is absorbed by the group and not the one individual. So that individual doesn't bear the burden and can sort of carry on with life, relatively speaking. So there's a public policy decision made in no-fault insurance. And Wadhams is talking about that aspect in my example. What's the choice that was made, in this case by the legislature, to create no-fault insurance? Why did they do that? What was the rationale behind it? And we've just explored a reason for that. Those that say public policy shouldn't enter into it say, well, you caused the harm, you bear the responsibility. They look at straight lines. So the driver of the car who struck the pedestrian pays everything. And that's the way it should be. There shouldn't be a public policy consideration within these decisions. So Wadhams in part is responding to that aspect. He's saying there's a role for public policy, and in fact, historically we can look at decisions in the Anglo-American tradition and see policy choices being made within these precedential cases. So when we're looking at contract law, he's saying, that has a reputation of being stable and defined, he's saying it isn't as defined or stable as we might imagine, because there is this leeway given in public policy. That influences the decisions at the highest level of the courts. And I suggest to you that that's going to be something that will be a bit troubling as you go through the readings, as you go through the course. Now, I've given the Wadhams reading to situate that. To say, first of all, Professor Wadhams has been at this for a long time, several decades, and he can't give us a clear definition. Yeah.
If we can just go back a minute, when we talk about public policy, are we talking about the public interest or?
What do you see as a public interest in
Just
that
to
might help?
conciliate,
Sorry?
if you are faced with a decision that is related to private law, if you're being influenced by a public policy, you would consider the interest of majority or the interest of?
Yeah, there are different factors that the courts can take into consideration.
Mm-hmm.
So if we think of good faith, anticipating our discussion in a little while, the Supreme Court in 2014 said, we're recognizing good faith. Largely because the facts of that case, there was no other way to deal with it. So they were saying this situation should have a remedy.
Mm-hmm.
It was new law because Canada had not recognized good faith until then.
So
So there is a
what-
public policy or public interest, if you want to call it,
Okay.
influence in that drove the court to say, well, we're recognizing this, but their rationale was also steeped in the common law, saying, well, we have this idea of good faith or honesty that we can trace throughout the cases. It just hasn't necessarily been overtly enunciated. Is that?
Yeah.
So, Wadhams can't really give us a definition of private law or obligations, what's exactly being done. And I think we need to draw instruction from that. We're not going to solve this problem of what is private law or obligations. Instead, from a practice point of view, what we're looking at is how do we operate within that system? That's what we're going to do. How do we put these cases together in a way that we can work with them? And by work with them, I mean providing advice and litigation arguments. Yeah.
Well, what I'm thinking is, as I'm hearing your lecture, is that there is completely another set of rules which is made by the government.
Not the government. Public policy.
Well, the public, what I'm thinking is that the public policy is the word used by the judges, creating common law occasion.
Yeah.
But, you know, the public policy is also what the government is claiming as
And that's something separate.
separate, but, you know, in your example, Consumers Protection
Yeah.
Act is a direct influence of the government that will create the rules that the judge will have to follow, because there will be certain limits where...
But they don't enunciate everything. So in the common
That's
law
true.
system, what we have largely are big gaps. And the courts take instruction from the legislation, but the legislation is sort of like, here's our philosophy. Go do your job. So public policy is something we see, well, in Ontario, we hear a lot about public policy right now. With the government. That would be something separate from what the courts are doing. What we're looking at, and maybe this goes further to your question, with public policy is, what's the rationale for the law, the legislation that we're looking at, for example, for the rules, if it's purely common law, and on top of that, what other considerations, if any, are the parties adding into this? So this is all by way of setting up the two decisions that I gave you to read. So let's look at the Rankin case first. Yeah.
Can I just add something?
Yeah.
So, I mean, I don't really understand why someone would object to having public policy, because in my view, this is a big part of what makes common law. Like, if you leave it only with certain specific rules, it would be a civil law jurisdiction.
Yeah, well, the argument is that with public policy, there's far too much leeway for judges, and they're not elected. That's the argument. I'm not expressing a view on either way, but that's where the argument comes from.
But then the whole legal system needs to be changed, you know?
Yeah, to some extent. But thankfully, we're not in the US, where it seems to be even worse. So, Rankin Garage, what happened in this case?
So essentially, you have a case where you're dealing with two minors who pretty much decided to get intoxicated smoking marijuana. And essentially,
With the mother of one of them.
I believe I think the mother left the home, didn't she?
Oh, did she?
So
The
basically,
mother was involved somehow.
So I think
Sorry?
She offered alcohol to the guy.
Okay, that was, I knew she was like, not mom of the year.
yeah.
Or mom of the year, depending on the side. Go ahead.
So essentially, after intoxicated, they pretty much break into a commercial garage.
Yeah,
And the vehicles on the property itself are unattended and they have the keys within them.
right,
So essentially, one of the miners steals cars, pretty much entices the other one to get in.
yeah,
And they get onto the highway, get into an accident where one of the parties gets a significant brain injury. in
yeah,
an accident. And essentially, it's basically that claimant who decides to sue the driver, the mother, and the owner of the commercial property for negligence.
right. And we're focusing on the commercial property aspect,
Yeah, so
because the other parts were put aside. Only the garage's liability went to the Supreme Court. Are there any other facts that are pertinent here?
And the question is, where is the time?
That's the legal aspect, but further facts to this. What was happening in the area at the time? Were the police involved? Before this? So, before this happened, the police had warned people in the area to lock their vehicles because there had been a high incidence of auto thefts. So this isn't a matter of just two kids randomly picking a car. There was a problem in the area of auto thefts and reckless driving. Anything else?
I say that there's no evidence to show that this is a site that kids are usually attracted to. So these no reason say that there's a high probability for kids to steal car and drive recklessly and cause harm. So
Yeah. So how did the court find? What did the majority find?
That the owner of the garage wasn't liable.
Why?
So it came down to mostly proceedability of harm and pretty much a proximity factor. And basically said that although stealing a car that was unattended with keys within them is foreseeable, what wasn't foreseeable was the reckless manner in which the kid decided to drive the car, I guess.
Right. So we'll just do this very loosely because we'll get into more detail with the court later. The majority focused on the duty of care aspect. And they said the test for duty of care was it reasonably foreseeable that harm would come about from this conduct, and then are there any public policy reasons to negate that? And the majority said this claim fails at that first stage, that it wasn't reasonably foreseeable. Now, as Valkar said, and I'm just repeating, he got it right, repeating the point, the majority said it wasn't reasonably foreseeable that two minors would steal a car and drive recklessly. Therefore, there was no first stage success in establishing a duty of care. And we don't need to look at the public policy. What did the dissent say?
The dissent actually suggested that the prima facie case was made out, and therefore they need to go to the next stage. Essentially, a duty of care does exist, and the duty was breached.
Yeah.
And the only thing to prevent that going further is whether there's a public policy not to find the breach as liable.
Yeah, they found the opposite of the majority. So here, forgive me if I'm repeating what Foundations talked about. You have majority decisions, minority decisions, opinions, and then a dissent. Majority and minority will have the same conclusion, but for different reasons. What we have here is a majority, and then a dissent that says the majority was wrong. So we have very divergent opinions on the same set of facts. Now, why did the dissent say there was liability?
The question came down to not just a question of general liability that cars were going to be stolen by individuals, but specifically which individuals. And that there was no liability, there was no perception on Rankin's point of view that specifically minors would be stealing cars.
That's the majority's point.
That's the majority point.
Yeah.
But the dissent is suggesting the complete opposite, that
Yeah.
there was actual enough evidence to suggest that that minors will be involved in the theft as well. They didn't make that unique distinction between the two groups.
Yeah.
That's the issue.
Established the duty of care.
Sorry?
The dissent established the duty of care.
They said everything was fine. This is a winning case. So, this is an important decision. And we'll get into it in a bit more detail when we look at it in court. But here we have a difference of opinion as to what the test is. Specifically, what does it mean when we say that the defendant's conduct reasonably foreseeably caused the harm to the plaintiff? What do we mean by that reasonable foreseeability? The dissent says we mean this in a more expansive way than the majority is talking about. As noted, the majority said it wasn't reasonably foreseeable that minors would steal a car and drive it recklessly. The dissent is saying we don't need to identify who does it. All we need to know is if Rankin left keys in the car, is it reasonably foreseeable that the car would be stolen and that some form of harm would ensue? And the dissent is saying yes. So we have the same test being applied or interpreted in very different ways. Now, we have to focus on the majority because that's the law. If the test is reasonable foreseeability, regardless of whoever the defendant would be or the plaintiff would be, why is the majority reading this in a narrow way?
I think that one of the reasons that at the starting point, the majority reads as a normal case because they see there is no established categories for this such scenario. So they treat it as a normal case, so they apply a higher threshold, so the more stringent analysis. But for the dissent, they say that this is a kind of physical harm to.
This is a traditional tort, negligence claim.
So the threshold is low.
Yeah.
So the kind of same test, but the different.
But why is the majority doing that? Valcar?
The way I extrude it, you get potential floodgate argument. So essentially, if you're expanding that scope, then you're pretty much far more onus on the individual, on the garage owner, for instance, to take these extra precautions in order to avoid these foreseeable harms, right? And I think when it came down to it too, it wasn't foreseeable that explicitly that two intoxicated minors will take the car, they'll drive it recklessly until the highway, get into a significant accident. I feel like they're putting too much onus on the owner himself. So I think it might come down to that floodgates argument that where it might become completely unworkable.
Kind of, we're getting into some of the territory of indeterminacy. The majority is concerned, and let me play with the facts a bit, that if you left the keys in your car, in your laneway one night, and two minors stole the car they were intoxicated, drove recklessly, and caused harm to another, that you would then be liable in some way. And the Supreme Court the majority is saying, we think that is not reasonably foreseeable. We think that's, put another way, too remote. Now, I have a problem, their language is loose, and that's part of the difficulty in this. But what I think they're trying to do is say, we're expanding negligence, the duty of care, very far, and they want to contain it more than the dissent. Whereas the dissent is saying, this is the test. We have to read the test as it is. Yep, and then I'll come back.
Well, I'm just, I'd like to understand what you're saying, that this is a good example of actually the public policy.
Well, that's what shows it.
Which was not disclosed. This is undisclosed, yes, in between the lines.
Yep.
What might be there, because nobody wants to be, in the middle of ongoing litigation for everything and anything somewhere.
No, but this is the role of the court. I don't think we would expect the legislature or the parliament to step into that kind of a scenario. This is a perfect scenario for a court to resolve. How far does the negligence analysis take us? What are the outer boundaries? And the Supreme Court, the majority are saying, these facts are too far. And I think we can very readily criticize the Supreme Court. For example, I would say, what car that's stolen isn't driven recklessly? People don't steal a car to drive it around patiently. So, of course, the foreseeability of something going wrong with a stolen car, I think, is probably higher, coupled with the fact that, as I noted, in the area, there's a high incidence of thefts of automobiles. So this wasn't just a random instance. Yeah.
Just wanted to check conceptually where remoteness sits in a tort, and I'm sure we'll get there.
Yeah.
I come from a bit of a muddled tradition where it's South Africa, so it's a mixed tradition. And we use remoteness in determining whether or not somebody should be held responsible for, or rather whether there's legal causation. So we split out causation into factual. Okay, but it appears as though remoteness is used in the negligence aspect of the tort as well.
The duty of care. This is part of the criticism I have. There are four elements to a negligence claim: the duty, a breach of that duty of care, causation, and remoteness. What I suggest to you is the majority, in trying to limit the scope of the duty of care analysis, brought in remoteness language. Not like this. Reasonable foreseeability was, is it more or less what the dissent was saying? It's a bit more open-ended. What the majority was trying to do was say, well, reasonable foreseeability should be more confined. If we think of Rankin in this way, if I were to say to you, Rankin is liable for something that happened where two kids got drunk. They broke into Rankin's garage, broke into a car, drove the car, were reckless, had an accident that caused severe brain damage to one of them. That sequence of events, that string of events, is what the majority is saying is, well, that's not reasonably foreseeable. That specific sequence, we can't attach liability and tort to someone for that sequence alone. But as was rightly pointed out, when we talk about remoteness, that's more or less what we're talking about. How could someone predict this event happening? But coming back to my larger point, and we'll get into the details later, is the Supreme Court majority made a public policy decision in terms of the scope of the duty of care analysis, specifically the prima facie duty of care, that first stage of the analysis. Other questions?
Yeah.
Yeah.
I think it's in England, it's a case similar to
Sorry?
this one. In England, it's a case similar to this one. They forgot also the key in the engine, and someone else came and stole the car, and they knocked a woman, and it was died. And it's the husband of the woman sued the company that owns the car itself.
What did they sue for?
They sue for he breached the duty of care. They sue that he needs more money, vicarious liability.
Okay.
And based on this case, they say no, the damage, it was so remote and it wasn't foreseeability. We can't see this one. We can't predict the sequences. But they didn't go through until the public policy in order to negate the duty of care that was established in the first system, because the duty of care here is, we didn't establish the breach, the negligence elements, the four elements of the negligence itself. We don't need to go through the whole thing and look at the public policy in order to do so. It means that the condition of the negligence were not satisfied from the beginning. It's an England case, established, I think, from 1967. It's related to the negligence itself.
Okay. I don't remember it offhand.
I'm trying to
Because
find
I've taught English law as well.
I'm trying to find the case itself, but I couldn't now.
So if we just take...
It's an old rule established.
If we take the principle, just from what was described, there are different ways of arriving at the same conclusion.
Yeah.
The Supreme Court here, I would suggest, did it in a way that was unhelpful. It was confusing.
Yeah, it's in Edwards' case, I
Sorry?
think. It's in Edwards' case, I think. If it's a law society or something like that. Because in England, they do it in three limbs.
Yeah, they have a different test.
Yeah, it's 3 limbs. But here, they put the first one and second one together, and
Yeah.
then they go to
Canada uses the old test from the second.
old test one.
Yeah. So let's move on to, what's the other case? Tell us.
So you think that the result was okay, but you didn't get, the way how they get to this result
I'm
is
sort of
confusing.
ambivalent about the result. I understand the choice they made and why they made it. To put it in sort of simple terms, if this was an exam question, they're really unclear. And next step concepts.
Well, what about that old saying, let the law slide where the cause is? I mean, obviously, brain injured guy will now be looked after the provincial funded help. He's not gonna get money from the garage owner for the grand out pet. And sort of speak, you have things in some kind of an order. Otherwise, you would have someone actually cashing out of the fact that he stole the car and almost tried to kill himself.
That's one word. Sorry.
David, just one question on ranking still on.
Yeah.
There was some discussion on whether the illegal activity of the...
And they put it aside.
Yeah, and it wasn't discussed much, but a sentence was used to say that it doesn't sever the proximity. The question was whether it severs the proximity relationship if you have an illegal conduct. Is that a settled law in Canada?
The law in Canada is a bit murky on illegality. So the concept, broadly speaking, is if you commit an illegal act, does that bar you from a remedy in tort, for example? And the court kind of didn't really satisfactorily deal with that. In Canada, I'm trying to think. probably best we not get into it. In Canada, it's not very clear. It's quite wide open compared to the UK, for example, where it's a bit more strictly applied illegality.
Because I think in Canada, they deal with it strictly as contributory negligence in some respects, and leave it like that. I think it's unsatisfactory so far as, well, it's so murky.
Yeah, well, I think in Canada, we'll find they're more willing to give something to a plaintiff than the UK. And that sort of feeds into our discussion about public policy, differences within different common law jurisdictions. So I'll just leave it at that and go on to the TELUS case. What happened here?
So Mr. Wellman had a contract with TELUS.
Who is Mr. Wellman?
Is a customer.
Yeah, what kind of a customer though?
It's not a business customer, it's a regular private customer.
Okay.
Yeah. So he noticed that the company rounded all the calls to the next minute without informing the customer.
Yeah.
So he decided to pursue a class action, and he went through this class action with 2 million customers. And the main point that the 1.4 million of those were private customers. Consumers, yes, and the rest were business customers. And the minor court offered the stay for and the main point in the contract was that any problem should be resolved through an arbitration.
Yeah.
The section 7.5. Yeah, and the main issue was the interpretation of this section, and the minor courts, including the appeal court, so they said yes to business customers. They can join the private customers in pursuing this lawsuit, class action lawsuit, whereas the Supreme Court said no. Although private customers, the consumers, they have this right as per Consumers Protection Act. However, business customers, they don't have the right to stay claims with arbitration agreement, because this might lead to weakness in the contract because they voluntarily.
Yeah, well, there was no permission given by the statute. The Consumer Protection Act basically allowed consumers of TELUS to sue and bypass the restriction of the Arbitration Act 1991. So the court has separated the litigants into consumers and business customers. And that's the premise of the decision. Why would they make that separation? Or, put another way, if we look at the legislature, why are consumers the focus only?
So back to the statutory provision, so we're dealing with the Arbitration Act and this comes back on the other side. Essentially, agree with the majority's rationale that when you're dealing with business clients, we don't want to limit the scope of their economy. They knowingly entered that contractual obligation, so they agreed to arbitration.
Yep.
Whereas the consumers would be excluded from that class, therefore it makes more sense for them to deal with that matters within court.
Okay. So, underlying the decision are certain assumptions that business people are, put sort of loosely, are more savvy in terms of contracts than consumers because they're in business. So therefore, they are going to be held to a higher standard, it seems, and there's legislation enforcing this separation in the Consumer Protection Act, that, let's not forget what the core of this is. that TELUS is rounding up calls to the next minute. Meaning, if you go 5 seconds over, they're rounding you up to the next minute. And you think of that on the aggregate, how many minutes would that amount to? So, to me, the question is why consumers and not the business people? And my question is more aimed at, are business people a homogeneous group? The difficulty I have with it is, when we talk about, and we'll see this in the cases we look at, especially in tort and contract actually, largely businesses are looked at as these big entities. This sort of traditional idea of a big company, like TELUS. And where they have access to legal advice, they are knowledgeable about contracts, they're savvy in commercial law. So the premise is, we the court, should not afford them this kind of leeway that we would a consumer who is just an average person that doesn't have that same background, doesn't have necessarily access to legal advice when they're signing on for a cell phone contract. But I don't know the figures in Canada, but I know the figures in the UK. About 90% of businesses in the UK are small businesses, small to medium-sized enterprises. So if we think about a small business being treated as a business person like a big company, like TELUS or Rogers, what I suggest is that is an unfairness. Because if our premise is a consumer should be treated differently because they are vulnerable, my question is, well, how far away from the individual consumer is a small business? Do they really have access to legal advice, and are they as savvy with commercial enterprise as a big company? So this is the difficulty I have with the TELUS decision.
And even if they have legal advice, isn't it like a standard terms of use that TELUS was offering to customers?
A
regardless
standard
of-
form contract.
Yeah, so even if you have the legal advice, the only thing you can do is not agree to that, but you can negotiate.
Yeah, it's sort of maybe a humorous way of looking at it, but I don't think the judges have bought a cell phone in Canada for some time. If you go to Europe, cell phones are great because you get the phone free and you get these wonderful packages. Canada sucks.
Any place in the world you go, you will never see a Canadian talking on the phone. You can hear Russian, Chinese, or whoever you want from Europe or Asia, but Canadians, they're like mules. Nobody has a phone, nobody has an ability to get the SIM card like this. Is just...
Well, I laugh at the Rogers commercials, roam for free, or what's their big thing? You can roam anywhere in the world, or you come back in debt. Just amazing how that is, and this is what surprises me about the decision, that the market in Canada is remarkably odd, but I'll be generous, compared to other countries.
Actually, I think helped TELUS. Because
Of course
the
it helps.
TELUS action was much cheaper for TELUS. They're gonna settle individuals for $15 a piece.
But
Out of our,
the Supreme Court cut almost in half, or at least a third, the number of people they have to settle with. That, I don't understand that. If we look at the idea underlying this is, didn't TELUS perpetrate a fraud? Wouldn't we call this a fraud in another way? If I sell you gas, and you go 1 cent over, and I said, well, I'm rounding it up to the next $5. That's not right.
It's a tax.
But the decision of the Supreme Court, I think here again, we're talking about indeterminacy. Because
I don't think there was indeterminacy here.
But if
Like, it was only TELUS customers. They weren't ripping off Rogers customers. Rogers does that quite well.
If the court extends the consumer protection to small businesses, like they recognize that a small business is also vulnerable. Like it might not have the resources and everything.
Yeah.
They would have to, like, what is a small business? Is it 1 person? Is it 5 persons? Is it 10
Yeah.
persons? Is it 15? So again, we do not know.
Sure, but the Supreme Court dealt with that. What was the argument that was missing by the small business people? Or, sorry, by the business customers? Sorry? No. They didn't qualify.
That's it, they didn't qualify.
No, but there's another argument. Unconscionability. The concept of unconscionability. That what TELUS was doing was unconscionable because they were rounding up the bill without notifying the customers. And the court says, well, this was not pleaded. So I raise that because that's your contract assignment. Unconscionability. So, and we'll come back to that. So the question would be, would unconscionability have helped the business customers in this case?
Was there a good faith on the side of TELUS in enforcing
I would think,
execution of the contract?
I don't recall that being argued, good faith. And I don't know if it was struck out earlier on. When you start a pleading, you throw everything in there and sometimes things get struck out. I don't know.
I was gonna say, I think that was like one of the arguments by the dissenting judgment as well. You know, there's specifically you say unconscionability. There was an argument of whether or not the lower courts had discretion in terms of overruling arbitration. And it was the dissenting judgment's view that based on statutory provisions, that where it says a court may, in some cases, pretty much overrule an arbitration clause.
Yeah.
And for those purposes, I believe.
Yeah, the dissent said they would have overruled this. So it was a close decision. But again, in terms of the concept of public policy and some of the themes we're looking at, public and private law, these two cases, I suggest, encapsulate these points and illustrate some of the difficult decisions courts have to make. And sometimes how they expose themselves to further criticism for missing something or whatever the case may be. And keep in mind, both decisions had a dissent. Not to say that that's everything, but these are two important decisions that have, in my opinion, strong dissents to them.
For example, for me, in my opinion, I go with the dissent because it was really unpredictable for the companies, even if they have legal advisors or all those like people that around them, like guiding them into the law, but they were not. Nobody can predict that this company will engage in a fraudulent act, like it's a fraud.
Yeah, well,
It's not
I'm
about
not
like
arguing.
having legal assistance or whatever. Even if you have the best lawyer as legal assistant, but you cannot, like, nobody can predict that, okay, they might like engage in fraudulent act, so you should like not accept this like boilerplate clause or whatever. It doesn't make sense.
Well, I'm not so sure who argued this case, but seriously, I mean, how someone was capable of getting money for unsolicited services. There was no contract at all. Where's the unjust enrichment? Like, you know, I'm kind of puzzled by the way how the arguments got framed by the time it came to the Supreme Court.
well, I think, particularly the business customers, the lawyers will be operating within the parameters of contract law, where it says there's freedom of contract. And your clients agreed to this contract. What that means is they didn't agree to be overbilled or extra billed, but they did agree to the dispute resolution mechanism, which is the arbitration clause. And because they fall on the wrong side of the Consumer Protection Act, they can't avoid the arbitration clause. So it's not necessarily a substantive issue, it's a procedural issue. And this is why we'll see this in other instances.
Well, there's
Dispute
no-
resolution clauses are sometimes mixed in with forum clauses, jurisdictional clauses. These are very powerful mechanisms for parties to sidestep lengthy litigation by shoving everything to private arbitration and the rules surrounding that. So the argument for the business people, the customers of TELUS, was, for the lawyers, is, well, you signed the contract. You can't undo that. So you have to go with the procedure set out therein.
Do we know if they went to arbitration?
I don't know. I would assume that that is something that is being worked out because it was decided this year, earlier this year.
I was more thinking that since there was no, they've been charging for something which was not solicited, there was no contract to them. And if there was no contract, then the arbitration clause pertaining to something else was not binding with regards to charging for unsolicited goods.
Sure, but it's a dispute. And the dispute resolution clause trumps that, right?
Only towards the part of the contract that is not void. The part of the contract that is
Yeah,
not
but-
in existence doesn't come
But
under
it's a
the
matter for
arbitration clause.
dispute, and that's the problem. Any disputes between the parties go to arbitration. So, as I said, here we see an illustration of some of the concepts that we've been looking at. I think they also introduce us well to some of the challenges we'll face with some of the decisions, working through the choices courts make. But again, and I'll underscore this, don't read through the cases looking for a straight line. Think of cases for and against either side. So there are distinctions that are going to be made, and they help one side, and other cases will help another side. I think it just becomes very confusing if you look for a straight line with the cases. Yeah.
David, just, I know you may come to it, but while reading this case, I had great
The Wellman
confusion.
case.
The TELUS case.
Yeah.
There was some play between Griffin and Sidel, the two cases, and one side relied on Griffin as the precedent case, and the majority relied on Sidel. And there was argument that Sidel had overruled Griffin. Is that something that we need to think about here? Because it's to do with, ultimately, the court had to decide whether in the interest of access to justice, they could have overruled the arbitration clause.
Mm-hmm.
And to me, those two cases dealt with that issue. In the case of British Columbia, the Griffin case dealt with it directly in the consumer protection legislation. But that wasn't clear in the Ontario. So I'm just wondering if you could shed any light on those two cases.
The way I understood your question was,
My question is, in the BC case where Griffin was relied on, and that was not accepted as relying on in this case, and I'm trying to question why. Is it because Sidel as a case lead in a different direction? I wasn't clear. There are two major cases
Yeah,
that
I'll-
I'm referring to
I'll-
here.
I'll look at it again and get back to you on that then.
Because a
But
third of
in
the...
terms of our discussion, it wouldn't lead us in either direction. It wouldn't be something necessary for our purposes. But in terms of the point you're asking, I'll read through it again and come back to you on that. Other questions? So tomorrow we'll start with offer and acceptance. This is the earliest we'll ever finish. We'll start at 6:10. I assume many of you work, and York is kind of hard to get to. So I'll give some leeway for that. Bring your name cards if you can, please, and just make sure you've signed in. Otherwise, I'll see you tomorrow.